It is May 15th, 2026, and this is the Court Gallery. Welcome back, ladies and gentlemen. Today's hearings are a wild ride from start to finish. We kick off with a landlord who cannot seem to fix a dishwasher, a dryer, or the birds that seem to have decided to move into the dryer vent. Then, stick around for the moment a lawyer admits their client called the hospital to check on a tenant. And the judge's reaction is absolutely priceless. And we'll close it out with a defendant who claims she's on the right path, but the judge has one final simple test to see if she's telling the truth. You are not going to want to miss a second of these cases, ladies and gentlemen, and it all starts right now.
Wilton Crossing 1 versus Tammy Evans. Oh, everybody waving at each other. Oh no, watch her. Hello.
Hello.
What's your name? Oh, whoa.
And
Thanks. No.
it's on social media.
All right. And let's see, where are we on this? You had indicated there were certain repair issues for you.
Yes, sir.
Did those get addressed at all, or where are we? So they didn't get addressed. Nobody came over, or what?
Hey,
Wow. Okay.
See that the bedroom window leaks, and then what's going on with the dishwasher? Is it just it's not working, or
it's not working and it's full of water. And it's a smell come from it in the washing machine and the dryer. It's messed up.
Wait, I had
The washing machine,
here before, it was the bedroom window. There was then the washer and dryer
and dishwasher.
and the dishwasher.
Yes, that's it.
And I think when we did that, because we were on Zoom at the time, that Mr. Fink was gonna try, I think he was here,
Yes.
gonna try to get somebody over there, but nobody's come over yet.
No, sir.
All right.
Your Honor,
All right. What do you have as the,
balance currently $927.
okay,
How much?
so,
$927.
so she's paid quite a bit. I mean, she paid, because I had that she was gonna pay $1,500 by Monday. That would have brought her into $2,000 range, but she's obviously made another
No.
other kind of pay.
Your Honor, the balance that I have is $927. It looks like there was on the 8th. I'm gonna have to, I don't have the ledger that we had that date, but I will follow up. Does the 927 sound right to you? Or does it sound lower than what you would?
I'm not sure.
Okay,
I just want to be able to pay what I owe.
right.
Hang on. So here's what you told me. So last time we were here, the balance that was given, including court costs, was $3,687. She had indicated she was gonna pay $1,500 by Monday.
That is correct. And
I paid
Did you do
it.
that, ma'am?
Yes, sir.
Okay, she did that.
so I don't know what the discrepancy is, Your Honor, but obviously the balance that on this ledger on May 8th is different than what
Right.
we would have had last week. And so what
Gotcha.
I do is, I don't know if, this, is it subsidized, your, the rent subsidized?
Section,
Okay, so that might have been it, like a payment came or something.
Yeah, that might be.
Okay, got it.
Double check though.
Okay, so I'm gonna adjourn it out a week. I want the sheet. I want these repairs done. Because as I recall, she told me the last time she's been living with these for a while now. She asked that they be done, and I'm not saying that they can fix them all right away, but somebody needs to get over there and check on them. And so I want that done before we come back next week. So I'm gonna adjourn you out. What? Yes, me. No, it's okay.
I can't come in person because I get off work at 1. I work 5 a.m. to 1. So I can't unless it's later.
Your Honor, do you wanna?
So you don't want to see me?
I love to see you.
No, it's okay. It's okay. No, I'm not.
Ah,
You know, people are offending me all over the place today.
I don't want you to be offended.
All right. I know. All right. So you get off of work at what?
5 to 1. I work 5 to 1.
Do you wanna adjourn it out
2 weeks. Okay. I'll do this for you, okay? 29,
Okay.
2026 at 2 p.m. Will that work better for you?
Sir,
All right.
dated.
See, I can be nice. All right.
Oh, nice.
You take care. You have a great weekend. All righty. New Park Ridge versus Sydney Dodd.
As this dog comes up, Your Honor, we spoke previously and she did different block application.
Yes, and hello, what?
Hi, Sydney,
Okay. I have a note here that Ms. Dodd has been approved for $1,652 in rental arrearage. She was approved on the 13th.
Oh.
How much was that? 1652.
Your Honor, the balance that I have is 1654.
I think your math is off by $2. All right. So she was approved for that, but you guys don't have the check. So let me ask you this. If you had to
yes,
come up with the $2,
yes, I'll pay it.
I should make her not pay it. So
I do got a question though.
that she would pay it.
I would. I got babies. I gotta keep my house. I said I got babies. I gotta keep my house.
I got you. What?
So I'm not sure if you remember, but the last time that I was here, it was the furnace issue. You had stopped it and dismissed the case that I had before until that was fixed. They did have somebody come out. It was during the winter earlier this year.
Okay.
They did have somebody come out, but they weren't able to connect the air. They had to basically rig it kind of to just get the heat going for us. I'm back and do
now,
but they
air
have it came. So I was trying to see if somebody could come out. I've emailed a couple times, but still nothing. And then also we have a bird now in the dryer vent that I had asked for them. Like they keep coming through the outside. I don't know. I just here and I ran outside. So I don't know. Yeah, so it's live bird. And so they just keep coming back and forth.
Going to invest?
Oh no, I don't do animals. I don't, But they keep
What, all animals or just birds?
I'm scared of birds. I don't know why.
Okay. Me too.
Okay.
All right. I just don't like them flapping around. I got you.
So
All right. So when are we gonna get that bird out?
they so that's the thing. They go out, but they come back in. So I had spoke to them about they were supposed to put a sheet up or something like that, but it still hasn't been done. So if
All
you
right.
put one up for
So
me.
here's what I'm gonna do. Bird in the vent. I want somebody to check her air conditioning because
Yes.
if that blower doesn't work, she's not gonna get air.
Okay.
And then do something about that bird.
Please. Please. Bird.
So I'll adjourn it out to the 22nd, 2020. Well, if the check is on the way, let me go to the 29th. I'm gonna go 2
Okay.
weeks out, let them try to get out there and get that all solved. And then that's at what? 2 p.m.
That's beautiful.
Okay.
What day is that? The
That's
20
29th.
What day is it?
Oh, Friday.
Friday. I might be in class because I'm in the nursing program, but we have clinicals and they switching our schedule, but I think we're switching to Fridays. So, do I have to be in person?
You're supposed to be in person, but
I can talk to her. I'll ask my teacher first if I can step
Okay.
aside because it's right down the street.
so here's the issue. I don't want you missing class, but because the issue, I don't want you missing class to get down here.
Oh.
You think that if I gave you Zoom approval, you could appear via Zoom?
That's fine.
All right.
I asked her to first. I'm right. It's literally right here by St. Joe's. So I'm not far, but I just want to make sure that I'll be able to step out.
Okay. All right. So we'll work that out. We're
Okay.
nothing. The worst thing that nothing's going to happen. I just want to make sure that these repairs are done and that they get the check over,
Thank you.
and we'll do that. Okay.
All right.
So when are you going to be a nurse?
February of 27. Yep. So next year, I'm almost there.
Next year?
Here.
How long you been doing
This year, it's only a 12-month program through St. Joe's. It's the first one through.
that St. Joe's?
Mhm.
Okay.
I work there.
That part of that are they connected with the nursing program at Washington?
Not yet. So I'll be doing the bridge program there. So I'm doing the LPN program right now, but I'm gonna bridge over to RN after I'm done in February.
Gotcha.
So that will be through.
Okay.
Yes.
Gotcha.
Yep.
Well, congratulations.
Thank you.
Yeah, that's fantastic.
Thank you. Then just.
Redwood Superior Township versus China Green.
Front thing plated.
Hello, your name?
Hungry.
All right. And where are we on her case?
We did receive a $3,300 payment that has been processed now, so she's at 1953 and 88 cents, including 175 of court cost. And I do want to put it on the record, there was an issue with my client accepting whips. We will accept payment by whips at this point for the remaining balance.
Whips.
The walk-in payment system where you can go to like Walmart or Kroger and pay for it. I've been trying to pay since Tuesday.
And they wouldn't take it. So you're gonna get this paid? When are you?
Oh.
When are you gonna have this paid by?
I can go after work today and pay it.
So here's what I'm gonna do. Since they wouldn't take her money, I don't understand why people won't take money. I'm gonna adjourn this out 1 week to the 22nd, 2026 at 2 p.m. If everything's paid, it's gonna be just. All right, sound good? All right, screen, you take care. Court calls case of Lori Anderson versus Irrational Lines. I'm sorry. Did we get the email to the court so that council's aware? It says that, hi, this is Irani Lyman. My hearing is got rescheduled until today at 2 p.m. I'm in the hospital and will not be able to make it. I want to see if I can get another agent, please. I will say, if council's not aware, I adjourned the last hearing because she had sent in medical indicating that she was in the hospital at that time.
Your Honor, my client is called the hospital and Miss Lyman was released on Sunday. And then here's the thing.
Wouldn't have given her that information.
Knowing Miss Lyman's the information.
Oh God, really? Exactly. You use somebody's information that you got for other purposes for the purpose of checking whether or not they were in the hospital. That is absolutely deplorable.
Still. Well,
And inexcusable. Absolute excusable. Well, not going to benefit you today. I'm going to adjourn it. I'm not. I can't even believe you did that. Adjourn this to May 29th, 2026 at 3 p.m. Thank you.
thank you. I've got one.
Yeah,
Apologize, we're gonna rotate the 29th. It should be
at noon.
went to.
Okay, yes, I went to.
All right. Well, we want to go there. So that's gonna be at noon
At noon.
at,
Right.
yeah,
You have Maple Heights.
I do.
Scott Gordon versus Michelle Mathis.
Both sides.
Good afternoon, Scott Gordon here. This is another Deborah Vard. Sides. Step on this side.
All right. Your name, you're Scott Gordon.
Yes, this is my significant other, Deborah Vard, Michelle's mother.
All right. Your name?
Michelle Mathis.
All right. And this is a termination case. Where are we on this, folks?
I have prepared something if you'd like to read it.
What is it?
It's just what I'm going to say here. In 2020, Michelle had to move out of her boyfriend's house and she was welcome in our home. Excuse me? Oh, thank you. And enrolled her daughter.
Okay, let me.
Okay.
Is there a lease?
No,
All right. And how long have you been residing in the premises?
2.5, and all I'm
Half.
asking, 2.5 years,
Okay.
30 more days until my daughter's out of high school for the year. I didn't want to move her out of Swanee, and she's in track and school. I spoke with this to
And-
Deborah,
Mm.
track, and she was in cheerleading. So I didn't want to take her out, and
Okay.
so she's
What
out June
Year-
4th.
What year? You need to take your hands out of your.
Oh, I'm sorry,
Is she?
15,
Hold on.
9th grade.
She's in 9th grade.
Yes,
Okay. And so. And you're looking for just to be able to finish the year before moving. Is that?
yes, correct. Yeah,
Your Honor, when she moved in 2.5 years ago, free room and board, we just asked that she give us some help and help do the chores around the house. That never happened. And we had many discussions about it.
Okay, so all of that seems to me to be water under the bridge. I've got a 15-year-old that's trying to make it through the rest of the school year. So she's just asking, she says she'll move, right?
yes,
She's just trying to get her daughter, was it?
yes.
Trying to get her daughter through the school year.
I understand that's why we waited till May of last year to ask her to move. And that didn't happen.
So you want me, when is her last day?
June 4th, which is 3 weeks.
No, I know it.
Okay, I'm sorry.
Calendar myself here. So you want me to kick her out before June 4th?
Actually, we tried to get her removed last year.
I'm not asking what you tried to do. What you're asking me to do right now is to kick her and her daughter out while her daughter's trying to finish up 9th grade.
Her daughter's welcome to stay.
How am I gonna have a 15-year-old stay and what the heck? I don't. In what world do you think that's right?
She stayed with us for many times.
So daughter's welcome to stay, but mom's not.
Mhm.
Why?
All we asked her mom was to help chores around the house and she flat out refused for 2.5.
Okay. I hear you. So what you want to do is you want to punish mom, ultimately punish daughter because she won't have her mom there, right? And that's the right thing to do?
At this point,
Okay, look, here's what we're gonna do. You may be entitled to a judgment at some point, but not today. So here's what's gonna happen. I'm gonna adjourn this matter out. June 5th, 2026. What time?
We don't have anything, I'm so
We
sorry.
don't have the 5th?
No,
So I'd have to go another week out?
yes.
Gosh, she'll be a week out of high school. Horrible things will happen apparently. I'll set it for June 5th, special time. What time? 1 o'clock. So I'll set this one special time, June 5th, 2026, 1 p.m. I'll deal with it then. Thank you.
Runner.
Sorry. 12.
No, June 5th, 1 o'clock. We'll just have a special time.
All right, let's talk to Natledge Zaretz. That's our next case. Ms. Zaretz, good morning.
Good morning. Good morning, Your Honor.
Good morning, Your Honor. All right, well, we have a 9:30 case that isn't here. That would be Kelly Tucker. And we'll come back to that and deal with the people that are here. We're quite a ways behind schedule. We got a little bit of a late start and then we had a complicated case.
Your Honor, I believe
this-
that one at 9:30 is a dismissal because my office indicates that they did dismiss one.
All right, I saw a couple come through, but I'll show that as dismissed, wait for the order, it's probably in the works. Very good. Then, Ms. Zaretz.
Morning, can you hear me?
Yes, I can. This is
Okay.
Riverside Townhouses with the Natledge Zaretz and Zan Zaretz. Both are present. Raina Haddad is here on behalf of the complex and the manager, Lori Kambach, is here. Miss Natledge Zaretz, you've been through this a couple of times. At this point, they just want you to move. They filed what's called a termination of tenancy.
Mhm. Yes, I'm aware of that.
All right, I'm gonna tell you what your rights are. I'm bringing some more people in here. Someone is here by telephone only. Who is that?
Me, Ashley
Ashley, what's your last name?
Whiteman.
That's my file, Your Honor. 1050.
All right. All right, Ms. Whiteman and Mr. Zaretz and Ms. Zaretz, you're tenants in a landlord-tenant proceeding. You have certain rights. You have the right to hire a lawyer. If you can't afford an attorney, you could see if legal aid would be willing to represent you, or you could seek other legal counsel. We don't have court-appointed attorneys in civil cases.
Okay.
Let me make a note here. In this case, they've asked to terminate the tenancy. In Ms. Whiteman's case, it's a demand for rent. In either case, you have a right, as I said, to have a lawyer. You have to hire one or see if legal aid would be willing to represent you. You have a right to have the case heard here in St. Joseph County where the property is located. You have a right to seek emergency financial assistance If you're unable to pay the rent, you may be able to get assistance from the Department of Health and Human Services, Community Action Agency, Neighborhoods, Inc., or other funding source. You may be able to reach a resolution with the landlord by going through mediation. If both parties are interested, the court can set that up, or you may be able to reach a conditional order of dismissal. Mr. Bradshaw does quite a bit of those. Also, if you wish to have a jury trial, heaven forbid, you must tell the court at this first appearance and be prepared to pay the $50 jury demand fee or make the written demand within 5 days using the jury demand form and pay the $50 fee unless the judge waives it for your inability to pay it. So, Ms. Zaretz, we've had several previous cases with this landlord involving your tenancy. At this point, they're asking to terminate your tenancy because you continually fail to put the utilities in your own name. And so they're asking you to move. But what's your position?
My position on that is that for the past year and a half, all the tenants here have received multiple letters on our doors. At least 4 to 5 a month. They've kind of slowed down for the past 3 months. I did let Lori know that there were a few times where I just did not get a chance to look at something on the door. My kids come in and out of the door and collect the letters. The bill was still paid even through adding it to my rent. And that when I finally became fully aware, I did make contact with her at the 10-day mark that the original paperwork sent to me said I had a chance to like work something out, and that did not happen. I kind of want to stress, like, I do want to move. I did hear the previous tenant's testimony. We have had termites here. We have had ongoing issues with the units out here. I've noticed that First Housing has prioritized vacant apartments over people that have lived here a while. Another aspect of the paperwork I got did mention late payment of rent. I'll go ahead and acknowledge that. That's due to the fact that my income changes monthly because it's mostly based on child support. From previous cases that we've had, there have been issues with communicating with the office and asking them how I should handle that if my income it changes monthly. And I was told by Kathy Cooley that the office at First Housing would be looking towards the person who has to pay it. They would be expecting them to pay in arrears, and that there was no necessity for me to recertify or do whatever would be necessary to change that. I did get the gas put back in my name, and I asked Simcoe to email them. Simcoe did not. Simcoe has a record of not really responding. There's been several times where Lori's asked me to.
Let me stop you for a minute.
Yeah.
They gave you a notice to quit in February. It's now late
Yep.
March. So you've known for several months that they wanted you to move. You told me you want to move. Have you made any provision to start to move?
Yes, I have. I'm talking to my sister. There's a chance that I could move to Atlanta, but I really wanted all of this stuff to go on record. That there's a lot of things going wrong here at Riverside. We do have termites. I have reported things over the years and got no response. Things haven't been fixed.
Let me stop you. Because if you want to complain about a bunch of other things, I'm going to give you an escrow order, just like the last lady. And even though it's a termination of tenancy, they claim that on multiple occasions over the years, you failed to put the utilities in your name. And finally, they got tired of it and they filed this notice to quit in February. So February is passed, they gave you until March, you didn't move in March, you didn't move in April, you didn't move in May. So the law says I have to adjourn this matter at least 7 days, which
Okay.
would be next Friday. And if they get what they ask for, you would get 10 days from that day to vacate. You've had legal aid represent you in the past.
Yes.
They're here today. I haven't seen Meg for several weeks. I'm not sure what's happened with them. But today is the 15th. I'm going to adjourn this to the 22nd of May at 11:15. Does that work for you? Oh, well, I've got a Riverside, no, it's Riverside Estates. That's a different thing, I believe. Yes. Does that work for you in your office, Ms. Haddad?
Yes, Your Honor, that should work, but Your Honor, I just wanted to make a note for the record. So the notice to quit indicates that the defendants have been late on rent payments on several occasions, and there's there's dates as to where they indicate that they received notices as to the non-payment of rent, in addition to not failing to maintain the utilities in their name. So it is for these violations, including non-payment of rent on multiple occasions, on 3 or more occasions, and then also not failing to put the utilities in their name, which the defendant made statements on the record just now that they did, that she acknowledges the non-payment of rent issue and the utilities as well. So this is just a termination of tenancy for these lease violations.
I think this may be the third Riverside versus Zaret's case. We've managed to resolve the others. But at this point, I think they've reached a point where they're tired of both of these things. Well, wow, there have been 6 of them. 191590, 242391, 251885, 26 1 2 3 1. This is the 4th action. The others were non-payment of rent. This is a termination of tenancy.
Correct.
All right, we'll revisit this May 22nd. The allegation, Ms. Zaretz, is you're continually late payment on your rent and you have not paid your utilities or put utilities in your name, and they're asking you to move. I would encourage you to contact legal aid. If you plan to move, that could resolve it, but it's a situation of maybe sooner than later. If they get what they ask for, you'd have to move by June 1st or be subject to being evicted. And legal aid has represented you in the past. I'd encourage you to contact them. But we'll address this again next Friday morning. I'll be in my own courtroom at 11:15.
Thank you.
Thank you. Ms. Zaretz, do you have any other questions?
No, I don't, but I do want to acknowledge that the utilities were paid, just not under my name. They were added on to the rent payments, and even though the rent payments were late, some of the months, they still got paid.
All right, we'll discuss that further next week. All right, let's go.
Thank you, Your Honor. I believe that concludes my cases for today.
Yes, it does. Thank you.
Thank you, Judge. Have a great weekend.
All right.
Thank you, Your Honor.
Thank you. Good morning. Welcome back.
Morning.
It's 10:44. Time for our next case. It's entitled Neighborhoods of Washburn Lake LLC versus Brooke Beals and Stephen Beals. The manager, Kristen Guevara, is here, and Miss Beals is here, and Sarah Reed is here from the Palance Law Firm. We were here last week on May 8th, and the defendant indicated that she was going to be vacating, and her She had some illness in the family. Her husband was moving to California. And so I asked her when she logged in this morning, do you still plan to vacate? And Ms. Fields, what's your plan?
I have recently spoke with Miss Reed and we have came to the conclusion that I'm to be out by the 31st of May.
All right, that's a bit of an extension. Ms. Reed, what's the circumstance here?
Your Honor, so, in keeping with the statements you made on the record, I spoke with Ms. Fields, via email, and she requested, to have May 31st. So I, this morning, sent over, a proposed conditional dismissal, just basically converting it from a non-payment to a termination case, so there's no redemption amount. And then, just indicating that they would, vacate the premises, surrender keys, and, vacate by May 31st. I wasn't quite sure about that date because it's a Sunday, and I wasn't sure if Your Honor would want that.
That's fine.
dismissal,
That's
but
fine. It's the end of the month. If we went with the order, it would be the 25th, so it's 6 extra days. Elaine, apparently there is a consent judgment in the queue in the neighbors of Washburn Lake. All right, do you need your office? All right, very good. I'll be done in a couple of minutes here. Thank you. As I said, I acquired earlier from the staff, they couldn't hear me because they were at the counter. Anyway, I'm looking for a conditional order of dismissal in neighbors of Washburn Lake versus Beals. It's not as urgent as the last one was because the defendant isn't here. So Ms. Beals, do you agree you're gonna vacate this property? Turn in your keys. They're not asking for any payment at this point. And if you don't move by the 31st, they could seek a writ of eviction. Do you understand?
Yes, sir.
Now, when you move, you need to turn in your keys and give your forwarding address in writing within 4 days of your moving. That triggers the security deposit law. They can apply your security deposit to any unpaid rent, utilities, or damages. If they wish to sue you for money damages, we're gonna have a subsequent hearing. Let's say the place is all broken up or trashed and there's damage they wish to sue for. That's not this hearing. If they do that, it'll be a subsequent hearing. So you agree to move and you agree to move by the 31st. And if you don't move, you're subject to being evicted. When you do move, you need to turn in your keys and give your forwarding address within 4 days of your moving. Do you know where you're moving to?
So I have a mailing address that I can give for now.
All right.
As of right this
Well,
second, I
you
don't
turn
know.
that into the manager with your keys.
Yes, sir. And I also want to make it known, I did tell the landlord or the manager about it because when we bought this home, when we signed the contract to rent to own the home, we got it for such a cheap amount because the previous owners had flooded the house and we were going to fix it up. So what they did is they stole the water softener system and they never shut the water off. And the entire house flooded. So all of the subflooring is falling through with us living on it for now. We planned on fixing it up. We've got one room
Well, you won't have to worry about it. You just vacate. If there are issues, we'll deal with it later. Sounds
Okay.
like you're lucky to get out of there. All
Yeah,
right, Miss
a little
Beals,
bit.
you're good to go. Thank you. I'll send you that order when I get it. Miss Reed, thank you. Look for that order and nobody can hear me, but I'll find it.
Do you want,
All
Your
right.
Honor, would you like me to just indicate that Ms. Fields has provided her consent on the record?
Yes, Ms. Fields, you did agree to that. She shook her head. Yes.
Yes,
All
I
right.
did.
Very good.
Okay, thank you, Your
All
Honor.
right, thank you. I'll see you next time.
Yep.
This is file number 26772LT. It's entitled, the name is Martin Andrade, but it's the Lauren Howard Trust. Mr. Andrade is there with Mr. Rognus at his office, and Erica Watson is here. Is Pedro Pedrosa there also?
Yes. Here.
All right.
I do not have legal with me.
You don't have who?
Legal aid with me yet, but I have spoke with them and was advised to ask for a trial.
All right. As often in some of these cases, they're a little screwy. This lease appears to be an original lease for the old Clinger Lake Marina, but there is no lease between Lauren Howard and Erica Watkins that I was able to discern. And they were asking for a rent of $200 per week. All right, Ms. Watson, this is not a great situation. Do you wish to stay here or do you wish to move?
Can I be honest with Your Honor?
Yeah.
I'm gonna move unless I could buy it, and I was told I couldn't. That was until I spoke to Miss Howard yesterday morning. She finally answered me back my messages. So
What did she say?
she asked me why I didn't get a mortgage and that I should get a mortgage. This house has a lot of potential, and I asked that, and I was told that's not an option, but according to her, so now I need to just find her.
All right,
And
so did Miss Howard tell you yesterday she would sell you the house?
she told me, yeah, she said I should literally just yesterday morning. I took a picture of it. I didn't make it to Centerville to drop some of this off to you. I'm very sorry. Gas is at $5 a gallon, and I went out and bought a truck last summer. And
All right, so I'm not even sure Mr. Andrade or Mr. Rognus, are you aware that Ms. Howard has been having conversations with Ms. Watkins?
Completely unaware, Your Honor, and I think that's probably a violation. If Ms. Watkins were an attorney, she'd be violating the PRE.
I don't know what that means, but I used to work for Miss Howard. I was her bookkeeper, so I actually know her on a personal level, and I told Martin that. I'm sorry if you didn't listen.
All right, well,
I asked to buy.
All right, Andy, this is in an odd posture. That's a diplomatic way of
Yeah,
saying
and not only that, Your Honor, the village is gonna cite this thing for all kinds of code violations because Ms. Watkins has not been taking care of the property, and there's an outstanding.
That's not true.
800. Well, we've got the city or the village sending a letter out dated March 16th regarding the condition of the property. And there's also a water bill that's outstanding at $849 as well.
I was at the water bill place yesterday, as a matter of fact, and I talked to Sue, lovely lady, and she informed me that you guys were there and demanded they shut my water off. It's not in anyone's name. We do have a contract to pay the water. My receipt says 7 something, but hey, I get it. Things get messed up, but yep, I have a payment plan.
Just a minute. You said somebody went to the Village of White Pigeon and asked to turn your water off?
Yes, they said that he demanded my water be shut off. And so she then went to the chief of police to say, what do I do? And he came here to have me, and I went down there and talked to her. She knows me. I explained the situation. Okay, I'll go give her something Thursday, and we're good. And she told me about this, and she don't know who these people are. She said, "Do you know who they are?"
Stop. Mr. Rognes,
Andrade said they're not gonna pay this bill. That's all that he said to Sue down there.
Well, it prompted them to call the police. Mr. Andrade, that could very well violate the landlord-tenant lockout law. And you could cost your principal a lot of money. You can't shut off somebody's water. So anyway, there's a factual dispute. Anyway, this is a mess. And we're gonna need to address it further. The day of the golf outing will be a perfect day to do this, but
No, it wouldn't, because I've got to work that day and you gotta be there too.
all right.
And Your Honor, an escrow order as well.
Yes. Well, there's no lease. I'm not gonna grant an escrow order with no lease.
Well, this is a non-payment case, and
I know, but I don't know how much the rent is.
She acknowledged a week ago it was $800 a month.
Well, I also heard $200 a week. This is a typical back of a napkin kind of a deal. Your principal is talking to the tenant behind your back.
Well, the tenant shouldn't be talking to the principal. If she were licensed, that would be a violation of the rules of professional.
Well,
Lauren's a common friend. I'm sorry.
Stop. So there's all kinds of issues. She's apparently got the water situation straightened out, but let's look at where we can move this to. How about June 5th at 2 o'clock?
Not a good day for me.
Okay. Let's take a look at that. I'm gone the 12th. How about June 8th?
Yeah, I've got two landlord tenants with you at 125 and 130. So yeah, we can pick it up after that.
All right, let's set it for 122.
What?
We'll just put it in there.
1:22 PM?
Yes, on Monday the 8th.
You sure you don't mean one? I've got stuff set with you at 125 and 130. You want to set it after the 130?
No, I've got something else set. So I'll set it in there. 125. I'll set it for 127. The 2-minute difference is just so they could fit it in the calendar. But Miss Watkins, and Mr. Rognes, you and your client need to figure out what Miss Howard has got going on behind your back. I don't want to do an escrow order because there's no lease. This is all screwy. Mr. Andrade's authority to act may be being undermined by his principal. She's working out some sort of agreement to purchase it. Mr. Andrade doesn't own it, so she can agree to do this if she wishes to. But you're rowing in one direction and she may be rowing in another. Miss Watkins, Mr. Rognes asked me to do an escrow order, or are you to pay money to the court? And I hold on to it. I would suggest that you set this money aside, because at some point, unless the case is dismissed, I'm gonna order that you pay the back rent. Last time it was $4,084 that the rent is in arrears. All that is in dispute.
Yes, Jeremy.
All right, we're gonna continue this to Monday, June 8th.
Now, okay, I'm sorry, I'm confused, but when do I say I wanted to do a trial?
Well,
The
discuss that
advice
on
I
the
got.
eighth.
Okay,
Legally,
sorry. Okay, that's what I
again,
needed to know.
this is ugly. I at least want to get everybody on the same page.
In their defense, can I say something? And so they know? I sent messages to Lauren before they were even involved. I wanted to buy this house. When they showed up, I said that, and they told me it wasn't an option.
All right,
Yeah.
well, maybe it's not.
So I wasn't started,
There are all kinds of zoning violations.
which I could get fixed if I owned it.
All right, so it's not just junk in the yard, it's things, it's like, what kind of issues is it?
There is no, I don't know what they're talking about because the code guy came and he was talking about stuff in the house, which are repairs we've been making. I have a stack of receipts for all this. Every summer, spring, we take a pile of trash from the backyard to the dump from everybody else that has been here.
Well, let's assume there is a bunch of trash in the backyard, and whether it's yours or not, it's there. They're telling the landlord.
No, not anymore. It's not. It's not there anymore. I'm saying in the last 4 years, that's what we've been doing, digging in the dirt. Like I'm talking stuff that they burned and yeah. So that's how long it's taken us to get where we are.
All right. We need more
And
information.
I asked for them to have the zoning people come out.
Okay, we'll address it further on Monday, June 8th. All right, Mr. Rogers, you may wish to bring Miss Howard into this conversation. Perhaps you could reach some conditional order of dismissal. All right. Good morning, Mr. Yoder. Can you hear me? I can hear you just fine, Judge. All right, thank you. This is Judge Middleton. I'm here by special assignment on a circuit court matter for the County of St. Joseph. I was familiar with this case earlier when it was a district court matter. The title of the case is People versus Timothy William Lewis Yoder. Mr. Yoder is present by Zoom with us from the St. Joseph County Jail. Also present with him is his counsel, Casey Strong. Also present from Three Rivers by Zoom is Assistant Prosecutor Angelique Canfield. We also got order here, and we've got some of the staff from the circuit court also present by Zoom. This matter is scheduled for a jury trial for the 26th, I believe, of February. Excuse me, February 26th of May. And the parties have been working on this for some time. And I believe to have worked out a resolution in this matter. As I've indicated, the original charge was bound over from the district court. The file number of the circuit court matter is 2025-25935FH. Mr. Yoder, the original charge alleged that on or about September 21st of 2022, that you did enter a home without permission at 2806 South Centerville Road in Sturgis with the intent to commit an assault. That is a felony. It's punishable by up to 20 years imprisonment and a fine of up to $5,000. Am I in the right case?
Oh, Your Honor, that's not I apologize. This is Timothy William Lewis Yoder.
Yes,
that's not correct.
Got the wrong file, so let me get the right file. There were some similar acts motions, so I copied all the other stuff. And let me get the right file. This is the proper case. The district court file number was 251947FY. The circuit court case number is 2525935FH. Mr. Yoder, the allegations are substantially different than what I was first advising you. This alleges assault with intent to commit great bodily harm, less than murder, with strangulation or suffocation against Angela Marie Yoder. That is alleged to have occurred in Lockport Township on September 21st of 2025. That is a felony. It's punishable by up to 10 years imprisonment and a fine of up to $5,000. Second count is domestic violence, third offense. It's alleged that you had at least 2 previous domestic violence convictions, which makes that charge a felony, punishable by up to 5 years imprisonment and a fine of up to $5,000. You're also charged as being a fourth habitual offender, which would make the assault, great bodily harm punishable by up to life, and also a 5-year felony as a fourth offender is also punishable by up to life imprisonment. It also affects the sentencing guidelines in the matter. Mr. Yoder, before we go further, I'm going to ask you if you would please raise your right hand. You swear or affirm any testimony or information you provide in this matter will be true to the best of your knowledge and belief.
Yes, Judge.
All right. As I indicated, this matter is set for jury trial, and I've been assigned to a couple of days worth of trials. This matter is charged, as I indicated, with assault, great bodily harm as a fourth habitual offender. My understanding is the parties have worked out a plea agreement. Ms. Canfield, what is the plea agreement in this matter?
Your Honor, it's my understanding that the defendant will be entering a plea of no contest to the initial count 1 assault by strangulation as a third habitual offender. At the time of sentencing, the people would move to dismiss count 2 and the remainder of the habitual notice. And I believe Ms. Strong will state the reason for the no contest plea is a higher level of intoxication at the time of the commission of the offense.
What is the maximum punishment for a assault with intent to commit great bodily harm as a third felony offender?
I'm looking at the statute right now, Your Honor.
And I'll defer to you, Ms. Canfield, stating the cap recommendation that is part of the plea agreement as well.
That is correct, Your Honor. We did have an agreement that the people would recommend a cap on prison time at 72 months, given our understanding of the calculation of the guidelines.
One habitual makes it half again as much, which would make it a 50-year offense. 2
Thanks, a
habituals.
third doubles it. It doubles it, Your Honor.
Right, so it would make it punishable by up to 20 years imprisonment as a maximum sentence. All right, Mr. Yoder, there's a lot to unpack here. We also discussed a no contest. Is it your intention here to plead no contest to these charges according to the plea agreement that was placed here on the record?
Yes, Your Honor.
Anybody threaten you to get you to do this?
No, sir.
Push you anything other than what was said here?
No, sir.
Do you understand that by pleading no contest to this charge, you'll be giving up your right to have a trial and there will be no trial? Do you understand that?
I do, Your Honor.
Now, I do these rights often in district court. They're a little bit more expansive in the circuit court. Do you understand that by pleading no contest to the charge, you will give up your right to have a trial in front of a judge or jury?
I do.
At that hearing, you'd have a right to be presumed innocent unless the state was able to prove your guilt beyond a reasonable doubt. You'd have a right to have any of the witnesses against you subpoenaed to come to court so they could be cross-examined You would also have the right to compel witnesses by the power of subpoena to come in and testify on your behalf. You would also have a right to testify on your own behalf, but you do not have to because you have a right not to testify. And if you did not wish to testify, the judge or jury could not hold your silence against you. And you have a right to have this matter proved beyond a reasonable doubt. And certainly you have a right to be represented by an attorney. Ms. Strong has been appointed to represent you. You could also hire an attorney if you wish. When you enter a plea in a felony case, you have no right to appeal as of right. You would have to ask for leave to appeal this matter to the Court of Appeals. And you understand that by entering this plea, you waive all those rights.
I do, Judge.
All right, Ms. Strong has provided me with the advice of rights, and I greatly appreciate that, Ms. Strong. She met with you in advance at the jail, and you've signed this acknowledgement of the advice of rights and this initial document for the Michigan Department of Corrections. Is that correct?
Yes, sir.
Now, the reason for no contest plea, as I understand it, is because you were intoxicated at the time this incident occurred. That is a legitimate reason for a no contest plea. By pleading no contest, you don't admit what happened, but you don't exactly deny it either. I would get my factual basis from the affidavit that accompanied the original complaint. You understand?
Yes, sir.
Actually, Your Honor, if I may, Ms. Strong and myself have agreed that the court may also look at the preliminary examination transcript and the original police report, which have been shared both with Ms. Strong and with the court. And I believe Your Honor oversaw the preliminary examination in this matter as well.
Yeah. Is that agreeable with you, Ms. Strong?
Yes, Your Honor, I have no objection to that. I've discussed it with my client. He also has no objection to that.
I'm gonna have to get into the circuit court version of this file because I don't have the police report in my file.
Your Honor, Ms. Wilkins emailed it to 3B District Court so that you would have access to that.
All right, that's probably very good, except nobody gave it to me. So 3B criminal you sent me those email messages late yesterday. And if there's an email at 3B criminal, would you please forward it to me? Lapita, I don't know if you can hear me. Anybody can hear me?
I can hear you, Judge. I just forwarded it.
Jen, would you go check on that, please?
Your Honor, I just sent you that email.
All right, very good. Let's see here. It takes a long time for that email to get from the jail to here. I do have familiarity with this matter because I did conduct a preliminary examination. While we're waiting for that, I did ask you if anybody had promised you anything other that was on the record. If anybody threatened you, you indicated they had not. Is it your choice to enter this plea of no contest to this charge of assault, great bodily harm as a third felony offense?
Yes, Judge.
All right. Now, there's been discussion on the record regarding the sentence cap and the sentencing guidelines. The court makes no representation regarding what the sentencing guidelines in this matter will be. I wasn't able to calculate them because I didn't know what the plea agreement was until just a moment ago. All right, but the guidelines will be determined at the time of the sentence. And the prosecutor has agreed to cap it if the maximum of the guidelines is 72 months. Do you understand?
And Your Honor, just to rephrase, my understanding is that, and my client's understanding is that MDOC will run their guidelines, whatever their guidelines are. The agreement of the parties is that the prosecutor will cap it at 72 months.
Yes, as a recommendation, that's correct, Your Honor.
All right, that's a good way to pin it down.
Does that make sense to you? You understand that? I just want to say it a different way.
I do appreciate we had a difficult time scheduling this. People are busy. They're in different courts. Judge Pattison was very busy in here. Angelique's in 3 hours. Casey was here, and then she has other obligations at Kalamazoo. We were able to accomplish this. All right, as I indicated, I did hear the preliminary examination in this matter on October 28th of 2025. Angela Yoder, Angela Yoder did testify at that time.
Your Honor, just as a correction, Angela Yoder did not testify at the preliminary examination.
This is the one where we have the officer testify in lieu of the victim being. But I do recall that testimony. It was full of excited utterance and other evidence that supported the bind over, including photographs. But I'll refer to the police report. The report was prepared by Trooper Andrew Stahl, the Michigan State Police, indicated they were dispatched to the scene at Woodland Drive in Lockport Township on that date, which was Sunday, September 21st. They met with a complaining witness, and she indicated that her husband, Timothy Yoder, had strangled her. They observed redness to the right side of her neck in the form of a handprint. Then they spoke with Timothy, who stated he did not choke her, but they further investigated this. Had to do with a dispute about a car, and there was photographic evidence of the injuries on the complainant's neck. She had apparent redness in the form of a handprint on the right side of her neck. She had what it appeared to be webbing behind her right ear. Webbing is caused from injuries sustained by a person who has been choked or strangled. Ms. Canfield, is you satisfied with that factual basis?
Yes, Your Honor. I would add that I believe the police report indicates that Ms. Yoder's statement, in addition to just saying she'd been choked, did verify that that meant to her that her breath was cut off for a time period during which she thought she was becoming unconscious. And I do believe that those satisfy the factual basis as elucidated in the criminal jury instruction 17.35 as well.
All right, will you accept that, Ms. Strong?
Yes, Your Honor, I would accept that.
All right. She also does talk about the defendant intoxicated at the time this was going on. He indicated that drinking and quite a bit and refused to take a test. So I find sufficient evidence of intoxication for this no contest plea.
Thank you, Your Honor. I believe if we could also inquire as to his habitual offender status.
All right.
He's going to ask me a question here.
Mr. Yoder, the complaint alleges that you had at least three previous convictions here in St. Joseph County. One is a conviction for, am I on the wrong one? We'll start from the newest to the oldest. Convicted in St. Joseph County Circuit Court on May 24th of 2000 of the felony offense of possession of methamphetamine. Do you acknowledge that?
What year was that?
Would you repeat the year, Your Honor?
May 24th, 2019, 45th Circuit Court, methane.
Yes, sir. Yes, Your Honor.
And September 12th of 2016, 45th Circuit Court, once again, possession of methamphetamine. Do you acknowledge that was a conviction and that was?
Yeah, yes, sir.
Are there any probation or parole consequences to this plea?
No, there are not.
All right. I think we've covered the fact that there will be no later claim of outside off the record promises or coercion. Once again, Mr. Yoder, was there anything that anybody said to you outside of the purview of this hearing which would have threatened you or induced you to enter this plea other than what was placed on the record here because of the plea agreement?
No.
All right. You seem very clear-headed here this morning. I find that this plea is voluntarily and knowingly made, and I will accept the plea to that charge of assault with intent to commit great bodily harm by strangulation as a no contest plea. The next thing we need to do is schedule the matter for sentencing. We had worked on that point, and the matter has been scheduled in front of me live here in this courtroom. I have a notice here. I got so many notices. I believe we picked June 19th. Let me look at that date.
That's correct, Judge.
That is correct, Your Honor.
June 19th at 11 a.m.
Thank you, Your Honor.
Mr. Yoder, I will be the judge handling the plea in this matter. Normally, I would ask if you would have any objection to it being assigned to another judge. We do have other judges that are fulfilling our circuit court obligations, but I'll handle this one. And this is an assaultive offense. I'm going to cancel the bond. There's no sense to leave it open. At the time of sentence, the domestic violence third offense charge and habitual will be dismissed. The additional habitual will also be dismissed. Probation department will prepare a pre-sentence report, which they will share with court and counsel. Will have an opportunity to review it prior to the sentencing on June 19th. At that point, we will be more specific with the sentencing guidelines in this matter. The court, as I indicated, has no position as to what the sentencing guidelines are. In the sentencing hearing, we will agree on what they are. The court will make a finding, and I will proceed according to the cap given by the prosecutor. All right, Mr. Yoder, do you have any questions?
No, I do for my attorney, but you can handle that.
All right, you can handle that separately. Ms. Canfield, is there anything else you believe we should have placed on the record here?
No, I will just acknowledge that I'm not aware of any threats or inducements or promises to Mr. Yoder to enter this plea either, and that I do believe that the court complied with the statutory taking of the plea. Thank you.
I'm supposed to ask that.
And yes, Your Honor, I also do not believe that Mr. Yoder was under any threat, coercion, or inducement not placed on the record, and I do believe the court has complied with the court rule.
Thank you. I do have a little checklist here. All right, Mr. Yoder, the next hearing in this matter will be June 19th at 11 a.m. for the sentence. I'm gonna ask everybody to stick with me for a minute. I'm gonna stop the record and close out the live feed. I want to inquire about some other matters. So thank you all for making time for this to happen. We went into the lunch hour at the jail. I know you're all very busy, but it was important to try to get this.
This is State of Kansas versus Allison Kiefer, case number 21 TR 2418. Would counsel state their appearances, please?
Jared McGee on behalf of the state.
Your Honor, Darren Patterson appear on behalf of Allison Kiefer. Ms. Kiefer does appear personally from the Butler County Detention Facility.
All right. Ms. Kiefer was picked up on a bench warrant. Where do we stand on this case, counsel?
Judge, there are certain plea negotiations we have entered into. I would announce this time pursuant to those plea negotiations. And this is pursuant to the amended information, Your Honor, so that she would be pleading guilty to count 4, which is failing to show proof of insurance or have proof of insurance after previous conviction for no proof of insurance. The agreed recommendation to the court at time of sentencing is an $800 fine, court costs for the court determined attorney fees, a probation fee, 6-month controlling sentence, and a 1-year reporting probation that can be transferred to her home county of Douglas County.
Mr. Regier, is that your understanding of the agreement?
It is, Your Honor. Count 4 of the amended information is charged as a Class A no proof of insurance, for which the statutory minimum fine is $800. So the state is making that recommendation. Insofar as the issue of courtesy supervision is concerned, the state does not take a position as it does not have any information as to the defendant's current circumstances. Upon successful entry of a plea of guilty to count 4 of the amended information, the state would move to dismiss counts 1, 2, and 5, count 3 having been previously dismissed.
Very well. But, Ms. Kiefer, have you heard what the attorneys have told me?
Yes, I have, Your Honor.
And is it correct you're pleading guilty at this time to count 4, which is no proof of insurance, apparently the second offense within a 3-year period, a Class A non-person misdemeanor?
Yes, Your Honor.
Have you had sufficient time to discuss this with your attorney, Mr. Patterson?
Yes, I have. And I'd just like the court and you to know that that I have very good support. I have.
Well, we'll get to that. Right now, okay. I need to take care of some other matters first.
I'm sorry.
Now, do you understand that with a plea of guilty, you're waiving your right to a trial?
Yes, yes, Your Honor.
Has anybody forced or coerced you in some fashion to enter this plea?
No, sir.
Do you understand that while there may be recommendations made on a sentence, the court is not bound to the recommendations? The court could, on the maximum penalties on a Class A misdemeanor is a fine not to exceed $2,500 and a jail sentence not to exceed 1 year in the county jail.
Yes, I do understand that, Your Honor.
And ma'am, on or about September the 16th of 2021, were you driving a motor vehicle in Butler County, Kansas on a public roadway with no proof of insurance, having had a prior conviction in the Lawrence Municipal Court on or about June 8th of 2021 for no possession or proof of insurance?
Regrettably, yes, Your Honor.
Very well. I find that the plea is knowingly and voluntarily entered with the advice of good counsel. Additionally, that a factual basis exists for count 4. I accept the defendant's plea of guilty, find her guilty, and I'll proceed to sentencing in a moment. Counts 1, 2, 3, 1, 2, and 5 are dismissed with prejudice pursuant to the agreement. And I'll hear counsel now in regards to sentencing if there's any additional comments to be made. And Ms. Kiefer, I'll give you an opportunity to speak as well.
Thank you, Your Honor.
Mr. Regier?
Nothing further to add beyond the fact that the state has no objection to the court awarding the defendant credit for time served in this matter, if indeed it appears appropriate. State's information is there was a first appearance before Chief Judge Rickey approximately 4 days prior, and the defendant appeared in the same fashion that she does today.
Thank you. Mr. Patterson?
Thank you, Judge. And Judge, the jail records does show she was booked into Butler County Jail May 8th. Judge, we would ask the court to adopt recommendations. She does reside in Douglas County, has other, and she's on probation in Douglas County, so that a transfer would be fairly easy for this case to be transferred there for her to have one place to report. She does understand she has to report in Butler County until such time as it is officially transferred, if the court would allow the same. So we would ask the court to adopt recommendations and grant her 1-year report and probation. Thank you.
Ms. Kiefer, is there any statements you'd like to make before I pronounce sentence?
Just, Your Honor, that I'm over 90, I don't know exactly how many days clean and sober. I'm working a program in Lawrence. I have wonderful support. I do have a job now, and I would just be forever grateful if you would send me back to I've got Douglas County Community Corrections and people there and meetings, and I want to continue the good course that I've been on for this last 90 some odd days. I just appreciate you listening.
Ms. Kiefer, what is it that you're serving the probation for up there in Douglas County?
I'm sorry. Actually, I'm not on probation anymore. I was on parole. And that is where I've got my connections with Douglas County Community Corrections, and then also TRC, which is the Treatment Recovery Center in Lawrence. So
okay. You still have it. What was the offense?
Oh, the offense. Originally, that was a I think a probation violation, but what I did is I absconded. I foolishly I left state, but there's zero reason for me to do that. I have good support now, and I have a job, and that's the most important. What I want to keep. I'm taking care of an 88-year-old lady who must be worried sick about me, and I just would love to get back to the support that I have there, that being TRC treatment centers and my program that I'm working. I'm 92 or 3 days sober of alcohol, everything. So I want to continue, and I'm doing away with even driving. I'm even giving away my car, Your Honor. I'm just going to take the bus system. If you allow me to go back to Douglas County, where I can get to and from my meetings and just do my I will be the best probationer person you've ever had. Promise you.
Okay. Ms. Kiefer, one of my concerns here is this is a 21 case. And
yes, I had a house fire.
Would you please let me
Yes, I'm sorry.
make my statement, and I'll give you a chance to answer my questions.
Okay.
But you failed to appear several times, and then there's long periods of time where you don't come up on the radar at all, it appears.
I was
What's with all these failure to appears?
I was actually in the Topeka, the Department of Corrections. I was in prison for the absconding, and so but in the year 2021, this is not an excuse, but it is. I want to give you a little bit of a background. I had a house fire, and in 21, I lost it, Your Honor, and I lost my father and my brother. Listen, those are not excuses, but I'm on a good path now, and I'd like to continue on the path that I'm at. And I have support in my hometown, and I can give you names. I have a sponsor. I can give you anything that, if you should feel free to check out anything that I say to you today. As far as support that I have there, and that I have been attending meetings, and I've been going to DECA, and I'm working their program. I'm working my sobriety, Your Honor, and I just want to continue on that sober path. And I believe that if I had the support of my hometown where I've been doing good, that if I could continue that, Your Honor, I promise you, you will have the best record ever of me. I just.
All right. Thank you.
Thank you. Thank you for listening.
In regards to count 4, I'm going to impose a $800 fine, which is the mandatory minimum. I'm going to order attorney's fees in the amount of $250.
Okay.
In regards to jail sentence, I'm going to order a sentence of 6 months in the county jail. I'm going to order that be consecutive to any other cases that you've got that have already been sentenced. After you have served 10 days in the county jail and you get credit for the time that you have, which if it's May 8th and today's the 15th, it'll be about another 3 days. But after you've served 10 days in the county jail, I'll grant you probation. You'll have to go to court services in Butler County, get signed up. This will be a standard Butler County misdemeanor probation. You'll need to sign the contract on that. Conditions are going to be report as directed and no law violations, plus the standard terms of those contracts, but no new law violations. That will include traffic misdemeanors. So I'm going to place you on probation for a period of 12 months, and I'm going to give discretion to court services if community corrections in Douglas County or Douglas County will accept a transfer of probation. I have no objection to that. They can do that, but I want court services to approve it. And you're going to have to report to Butler County at first, and up until and when, if it occurs, you're transferred to Douglas County. Ms. Kiefer, I'm going to be real frank with you, as I try to be with everybody, but if you come back on a probation violation, I'm going to take it as you're just not going to comply with the court's orders, and I'm going to probably order that you just serve your time.
Thank you, Your Honor. I really appreciate your willingness to have this Douglas County. It just means a lot to me. Thank you.
Well, good luck to you. Counsel, is there anything else you need to address today?
Your Honor, if the court is also ordering that the journal entry reflect appropriate court costs, the state has nothing further.
Yes, court costs are assessed to the defendant as well. Probation may work out a scheduled payment plan with the defendant. I would prefer that be done to where everything's paid within 11 months, but I'm not going to require that. But it, needs to be the contract signed and that she follow through with the terms. Anything further?
From the state, Your Honor.
Nothing further.
Very well. Good luck,
Thank you,
Ms.
Your Honor.
Keeper. With that, this matter is adjourned and the defendant can, once she's completed her sentence, the 10 days, she can be processed out. All right.
Thank you, Your Honor.
Next matter, Mr. Patterson.
And Judge, I need to find out court security. Do you have Nicole Hart there?
Jennifer Nicole Hart. This is State of Kansas versus Jennifer Nicole Hart, case number 24 TR 1842. Counsel state their appearances, please.
Jerry Gear on behalf of the state.
Your Honor, Darren Patterson appear on behalf of Nicole Hart. Ms. Hart does appear personally from Courthouse Security 3 video station. And Judge, just to review, Judge, this case was previously waived hearing, stipulated to for violations. The court set it over for a review for disposition and review of her treatment.
Yes, and I did receive an email, and I believe the state did as well, with a attachment, a document concerning her treatment. So our party's ready to proceed at this time.
Your Honor.
All right, I'll hear recommendations in regards to probation or consequences at this juncture. Mr. Regier.
One moment, Your Honor. Your Honor, this is a case that would appear to have a quite extensive history of violations, including the request for revocation, various UAs, failure to report, failure to pay court cost fines, indigent attorney fees as directed. If the court is prepared to order a sanction short of serve an outright service of the sentence, the state has no objection to the court ordering a section that the defendant be returned to reporting probation. It would appear that initially the defendant was sentenced in July of 2025 and was granted underlying sentence of 120 days subject to a reporting probation of 12 months. If the court does determine that it is appropriate for the defendant to return to reporting probation, the state would be seeking an extension of the same of at least 12 more months.
Thank you. Mr. Patterson, I probably should have asked earlier, is there any additional witnesses that counsel wish to call?
Your Honor, given that the defendant has already stipulated to the violations, the state does not intend to call additional witnesses at this time, short of needing, if the court is seeking additional clarification, as would appear to have been the court's inquiry and intention for purposes of today's hearing at the last hearing at least.
Mr. Patterson, any witnesses you wish to call?
Judge, we had just asked the court to admit, for purposes of this hearing, the client discharge summary dated April 17, 2026.
Mr. Regier, any objection?
No, Your Honor.
It will be admitted, and I believe that is the document that I referred to earlier, correct?
Yes, Your Honor. And Judge, I'm going to refer to that document mainly because it was set over to review treatment. I think that's an important aspect of this. She has from this document, it's very apparent there was a long history of addiction. That from this document, it does state very clearly that this is her first time really addressing that, and her best that she's done addressing that. There's different parts of the document that I would point out specifically, including a medical clearance status, that she was medically cleared to be released and go to work. So no acute medical conditions requiring ongoing inpatient care is what I would note it says. And I'm looking, the only page numbers I have, Judge, is from the fax number at the top. That's 14 of 20 is where I find that. I noticed that there was some indication of a discharge against medical authority, but from every page of this document, I couldn't find that anywhere. So
that's what I had recalled as well from looking at the notes from the last hearing. And it sounds like that had happened on prior occasions, but not this occasion.
And this report seemed to be I almost say a glowing report, but at least a report that would indicate she has made a good start, that she has a lot still to go, or a lot to go yet, with further outpatient treatment, further other requirements in here. They've listed out what they would require, recommend for her in order to stay on the path towards being drug-free. From talking with her, I think she's very much bought into the idea she wants to be drug-free. She wants to lead this better life. So we'd ask the court to reinstate probation with an order that she complete the recommendations and do these things that she is required to do in this report.
Your Honor, if I may speak.
Yes.
In a reference to this report, she did leave against medical advice. On that very first page of the report, it says type of discharge, AMA. So she did not complete the program. I just wanted to clarify that.
And Judge, I disagree. The report says different. So I'm not sure where that one AMA and then we throw out the entire report. So I guess I disagree, and I don't know. We have TJ Miller here. If somebody wants to ask him questions, I guess.
Can I just say something?
Well, hold on a moment. I'm sorry, I can't. How is it you pronounce your last name again, ma'am?
Taronis.
Taroni. Have you read through the whole report?
I have read through it, Your Honor. I was just clarifying where I came up with the against medical advice, because that's how the report is labeled.
Okay. Do you disagree with the statement that Mr. Patterson just made about in the body and description, it doesn't say that she left against medical advice?
There are definitely parts that I would agree with, but when speaking with the facility, when she left, they did not want her to leave. They wanted her to stay to complete the program, and she opted to leave.
Counsel, you mentioned that Mr. Miller that's present. Mr. Miller, where are you with? Who are you with?
I'm with Holland Pathways.
All right. If you'd raise your right hand, please.
Sure. Oh, sorry.
Do you swear to tell the truth, the whole truth, nothing but the truth, so help you God?
Yes, I do.
Mr. Patterson?
Please state your name.
Tori J. Miller.
And if Mr. Miller, you said that you are a therapist at Holland Pathways, is that correct?
Yes.
And are you familiar with Miss Hart?
Yes.
And in fact, were you a therapist for Miss Hart while she was participating at Holland Pathways?
Yes.
You sent in a report that appears to be 20 pages with your signature on the back page. Is that correct?
Yes.
Okay. Now, what I want to find out, as I read this report, and I'm going to kind of skim through part of this for you, you indicated in this report that, and I'm going to quote, Jennifer Hart's response to treatment demonstrated a remarkable transformation from initial resistance to behavioral challenges to sustained engagement and clinical stability. This represents the longest period of treatment retention in her history. Is that what you wrote in this report?
Yes.
So would you agree that she's got a good foundation started? She just needs to continue on with your other recommendations.
Yes, absolutely.
And what were your recommendations for discharge that are listed in this report?
So let me pull up the reports. So the recommendations were, I believe, OP, IOP. Hang on just a second.
Can you tell us what that is, please?
It's outpatient.
And I'm going to see if I can get you to a certain page. Are you looking, and I only have the fax numbers at the top right-hand corner. Mine says page 9 of 20. And it has a section called clinical recommendations. Is that the part you're reading from?
So I'm actually looking at it and I don't have page numbers, so I apologize. Oh, there we go. Yes.
Okay, so those are the recommendations you're making. Is that correct?
Correct.
Can you go down through those, please?
Sure. So intensive outpatient program, which is IOP, for continued therapeutic support. Sober living placement to maintain structured environment, continued MAT, which is medication assisted treatment, with the medication maintenance, individual therapy for ongoing trauma processing, psychiatric medication management for co-occurring disorders, and long-term recovery support, spiritual community engagement as primary recovery framework, regular drug screening for accountability, employment support utilizing medical work clearance, family therapy to address relationship dynamics, and trauma-informed care for continued PTSD treatment.
Now, you would agree that's a full plate of recommendations. In fact, a lot for her to do, correct?
I mean, I feel like it's normal, but yes, maybe.
Okay, so my question was going to be, is there, of those things, are there any that would you consider more of a priority that she should get on immediately versus things that can wait a little bit longer? She's working on some stuff.
Yeah, so at the time, it was my understanding that she was with Holland Pathways for a 60-day program. And as of, I believe, April the 17th, she was 40 days in. The day before she released, she approached me stating that she had reached out to her primary care physician and she had approached her insurance company and she had on her own approved step down into an IOP program. That was outside of what our recommendation was at the time. Our recommendation was the full 60 days.
Now, you don't have that in the report anywhere, is that correct?
I don't believe so. I was not there the day that she discharged. So I'm not there, and I believe the clinical director took care of that on that particular day.
Okay. Well, what I'm asking though, you signed this report, correct?
Yes.
And nowhere in that report does it recommend that she should have stayed there for another 12 days.
No.
No other questions, Your Honor.
Mr. Regier?
Very briefly, Mr. Miller, going down to what looks to be approximately page 11, do you see a section stated on treatment-related unresolved issues? Under environmental and social stressors.
And what was it, the label? Sorry.
Treatment-related unresolved issues.
Yes.
Okay. Do you see item 7 under that header?
Yes.
What does that item 7 refer to?
Premature treatment termination.
Okay. And could you please elaborate in further detail on what's contained on that page of the report?
It says client discharged against medical advice on April 17th, 2026, before completing recommended treatment, of course.
Are there any diagnostician concerns indicated in that section?
Yes.
And what are those concerns?
It says final progress note documented client's frustration with the treatment environment, quote unquote, this place is just not a good place for me. Anticipated discharge date was May 12th. Pattern of treatment prematurely when frustrated, and recovery impact, incomplete treatment increases relapse risk and may indicate ongoing ambivalence about recovery commitment.
Does this section indicate approximately how far before the anticipated discharge date the defendant was discharged?
Yes, 25 days early departure.
No further questions, Your Honor.
Thank you, Mr. Miller. You're off the stand at this time. Counsel, anybody else that you wish to call or?
Not at this time, Your Honor.
Judge, I would ask for a brief breakout room with my client before I make a final summation.
Before I'm going to grant that, but I'm going to ask what the recommendation of court services is. Mr. Roney.
Your Honor, honestly, this is a tough case. She does have a lot of history of leaving treatments, not staying in treatment, getting kicked out of treatment. She is in treatment currently. My concern is that they're virtual appointments and not in-person treatment. We actually do not allow virtual treatment, so she would have to switch to in-person if she were to be put back on probation. Ultimately, Your Honor, I'll leave the decision up to you.
Well, that's where it's going to be anyway.
Well,
That's why I was asking if you had a recommendation. Sounds like you don't.
I don't, Your Honor.
Okay. All right. I'll grant the recess. I'll remain available. We're back on the record, and we have the same appearances as before. Before I hear summations, I do have a question, Mr. Roney. Do you have the capability to do a urine test today?
Yes, we do, Your Honor.
Would it show results for immediately or no?
Yes.
How long would it take to get that done?
If she can go now, 10 minutes.
All right, thank you. All right, I'll hear closing arguments at this time. Well, first of all, any additional evidence the council wishes to present?
No other evidence.
None from the state, Your Honor.
Okay, I'll hear closings at this time. Mr. Regier.
Your Honor, this is a case that admittedly did begin its life as a traffic matter, at which time the defendant was convicted of driving while suspended, a Class A misdemeanor, and the court did enter certain orders, including a 12-month reporting probation, that the defendant shall submit to random reasonable breath, blood, or urinalysis testing, as well as not possess or consume alcohol or drugs. It would appear, based off of the request for revocation, that there have been a number of violations over the course of this probation. And the state does not consider this a successful probation at this time. While the defendant may have made certain progress insofar as treatment efforts are concerned, the evidence is clear that those efforts at engaging in treatment have been largely incomplete, per both the admitted document and the testimony of the witnesses. If the court is prepared to order that the defendant be returned to probation, the state is recommending a suitable sanction. I'll leave the date in the court's due discretion. However, if the court is prepared to order an outright revocation, the state would definitely not oppose that by any means, as the state's position is that this has not thus far been a successful probation.
Thank you. Mr. Patterson?
Thank you, Judge. Judge, when she was arrested on this warrant to show cause, she did approximately 3 days in jail. Part of that in Sedgwick County, part in Butler County before she bonded out. She bonded out so she could go to treatment. She did go to treatment. Judge, she has a good foundation to start and to move forward. She's built on that foundation by getting into an intensive outpatient treatment program, although sounds like Ms. Tronies does want her in a different one, and my client, Ms. Hart, will definitely follow that and jump into a different one if she needs to. And she is in a halfway house, sober living house. She is in a sober living house where children can be placed also. She's working on that currently to get her child with her, but that's, I think, a process she's still going through and has many tasks to perform and do for that to go forward also. So she has a lot that she is doing, but from the report that I read, it sounds like she is vested in it now, so that she does want to do that treatment and stay clean. So, Judge, we are asking the court to order 72-hour sanction, which with credit for time, and allow her to continue with her employment, her current living place, as well as treatment. Thank you, Judge.
Ms. Hart, is there any statement you'd like to make before I announce my decision?
No, I just wanted to make sure that you knew that I do have a job and I have an interview for a second job too.
Okay, you say a job, but you don't say where you're working, right?
I work at, sorry, it's kind of embarrassing because it's a nasty job, but I work at Dubia. They breed roaches for exotic animals. And I had an interview at Long John Silver's a few weeks ago, but I didn't have my social security card. And so she told me to send that to her when I got it, and I sent it to her. So I'm just waiting to hear back if I need to go back up there and talk to her or when I could start. And I didn't know that about the IOP being on Zoom, so I'll get that changed too.
Okay, anything else?
That's all.
Ms. Hart, I continued this case to allow you to complete inpatient treatment. We were in court on April the 3rd. I indicated at that time, we moved it to today at 1:30. You were to complete inpatient treatment. And I would consider another continuance if you were in another treatment plan at that time. You were to continue to report to probation, and bond was continued. You were to appear in person, which you've done. Looking at your history, and largely going off of the document that's been submitted by your counsel from the treatment center, Mr. Miller works. And it indicated you'd been in treatment, I believe it said 6 times, and left without successfully completing. And then as I read through this, and I'm not as well versed as others in regards to the abbreviations utilized in that field. I didn't catch the AMA, nor did I catch that you'd you'd left without completing the 60-day that they had recommended. I'm just kind of dumbfounded as to why you would leave against their advice and then start up a program you hadn't cleared with your probation officer.
Well, I knew that I had to get into IOP immediately, and that's what I did.
Okay,
I
when you
got
say
out,
IOP, what do you mean?
sorry, it's a inpatient, or I mean, intensive outpatient treatment. So I got out of Holland on Friday, and on Wednesday I started my intensive outpatient treatment. And it is on Zoom, but at the time, I just couldn't get a hold of anybody except for Valley Hope. And so that's why it's on Zoom. And had I known that it wasn't allowed, I would have switched it over immediately. I would have just kept calling, until I got a hold of somebody else. But another reason why I left is also because I have that driving on suspended case in Wichita that I got prior to this, like around the same time. Well, the judge gave me a 60-day like time frame before I could start paying on it to pay my fines or whatever, or it was going to suspend my license. And so that 60 days was already up, and I'm just anxious. I'm ready to get my kids back, and I wasn't getting anything from Holland anymore. Like we went over the same stuff like every day, just repetitive, and I just wasn't getting anything out of it. I was ready to start working. I have child support. I mean, I have 5 kids, and one of them graduates on Sunday. So I'm just trying to be there,
All of which would have been great reasons for you to stay and finish your treatment.
Yeah. I did go straight to sober living from treatment. The house leader picked me up, and I went
Had you
straight
been
there.
reporting to the court services since you checked out?
Yeah. I see Matt on Monday, my PO.
When I read through this report initially, I reminded me of a hearing I was sitting in the background for, waiting for my case to be called, where it was probation revocation, use of drugs and so forth. And the defense attorney was asked by the judge, well, how many times should this person go to treatment? Because it'd been done before. And the response, I thought was a good one, was as many as it takes. I don't completely buy into that, but I have seen cases where people get themselves straight that I never thought would, and different things had perhaps motivated them. But I also have to look here in regards to, you do have a history of trying to manipulate the system. And you knew what the conditions were, and when I sentenced you, you knew what you had to be doing, and you didn't comply, as you admitted to. Counsel, how's your schedule look for the rest of the day? Mr.
Judge,
Patterson?
I have one hearing at 2:30 that shouldn't take very long, like maybe 30 minutes at most, then I'll be free the rest of the day.
If I set this continue to say, give you a little more time than that. Mr. Regier and Mr. Patterson, can you be available at 4 o'clock?
I will make myself available, Your Honor.
Yes, Your Honor.
All right. for now, I'm going to revoke the defendant's probation. I'm going to order that court security take her into custody, take her to court services. She is to provide a sample, urine sample, it's to be tested. If she declines or says she just can't squeeze out a drop, then I'm probably going to just have her serve her sentence. Because there's been a lot of manipulation here. I want to know if you're clean or not. It's being represented that you're clean. That's what you're representing. And so I'll take this back up at 4 o'clock if I want that test result or know what's occurred. But I'm going to ask the court security keeper there at the courthouse till 4 o'clock. I don't want her transported to the jail. But Mr. Roney, can that be accomplished by your office, what I've requested?
Yes, Your Honor.
Ms. Hart?
Yeah, yes.
You know, do you want to tell me anything right now before this test is done?
No, Your Honor.
Okay. We'll take this back up at 4 o'clock and we'll go from there. And if there's witnesses you wish to excuse, counsel, that's fine by me. I don't anticipate any additional witnesses or requests for information other than that test result.
Definitely, Your Honor, don't need TJ Miller when we come back probably, so.
Yeah. Thank you, Mr. Miller. And you're free. It's an open hearing. If you want to attend, you can watch it on YouTube. So that's fine. All right. So we're adjourned till 4 o'clock. Thank you.
Thank you.
We're back on the record at 4 o'clock in State versus Jennifer Hart, 24 TR 1842. Counsel up here as well as the defendant. Mr. Roney, the probation officer, also appears. I had ordered Ms. Hart I'd revoked her probation and ordered her to take a drug test, UA. Mr. Roney, how did that turn out?
Your Honor, she was not able to produce a sample.
All right. I have reviewed the file and what the defendant had stipulated to. There were numerous and varied conditions or violations of the probation. We had continued these earlier for her to complete treatment. Their report had been submitted. However, the defendant left several days in advance of completing it, which has been a pattern. I'm going to continue with the revocation, and she'll be remanded to serve the remainder of her 120-day sentence.
I was gonna, oh, sorry. I didn't mean to interrupt you.
Counsel, anything further at this time?
From the state, Your Honor.
Judge, I do want to ask that we make sure credit for time is calculated. That would, in my opinion, I think that should include the inpatient treatment that she's entered into. There is certain case law that if it's court-ordered treatment, that it would apply if it was inpatient. This was court-ordered part of her ongoing case, so would ask for credit for time that she was in treatment.
Well, I'm not going to do that at this time because it was, if I recall correctly, well, are you talking about at the time of the revocation?
The one that she was in that the court had the report for, yes.
Well, counsel, I'll consider it if you want to file a motion on that with some case law on it, where the defendant gets to pick and choose if she's going to stay or not. I don't consider credit for time served, but Supreme Court and I don't always agree on things, so we'll go with whatever they've decided. But I'm going to need to see the case law on that first.
Yes, Your Honor.
Thank you. We're adjourned.
Your Honor, if such a prospective motion is filed with the court, the state would reserve the right to respond appropriately.
That's fine.
Thank you, Your Honor.
I'm telling you, if they're telling me that I can sit in the Gray Bar Hotel for the next 120 days, or I can find a way to get a little sample in an itty bitty cup. Yeah, that's not the right thing. That's not the right thing either. Oh my dear God. That's the right thing. Hey, good thing there was nothing embarrassing in it, right? Dear Lord, that could have been horrible. Anyway, actually, it couldn't have been that horrible because there wasn't really never anything embarrassing anyway. Guys, that's embarrassing. So anyway, back to the show, ladies and gentlemen. We started things off with a lot of landlord-tenant cases with Judge Simpson, moved into Judge Middleton. Man, I like those landlord-tenant cases. I know a lot of people don't, but I just think they show the humanity of the court and a lot of the frustration. A lot of the frustration the court can go through. And then we moved into our criminal docket with Judge Middleton, where he had a Yoder in front of him. I don't think it's the same Yoders that a lot of us think of. That guy did not look like one of those Yoders, but hey, it was a Yoder, right? It was a Yoder, and then moved very quickly into a kind of weird set of cases with Judge Lee in Kansas with a couple of women. Man, Twitchy Sketch, thank you so much for those jewels. They just zoomed right on by there. What you gonna do? Ladies and gentlemen, thank you so much for hanging out with me today. I do want to say a special thank you to all of these crazy people whose names are popping up on the screen right now. Twitchy Sketch, Marty Duvall, Nina out of the blue, Charlene Tut, Julie Sassy, and Kiranoth, all of you, and especially Rhonda and Mama Wolfie. Everybody say happy birthday to Mama Wolfie. She's got a birthday this weekend. I'm not going to let her forget it for the next 48 hours. And make sure you join us in about 13 hours from now when we have a brunch get together where we're going to do a weekend review. I've got tons of stuff sitting on the back burner that we just never got to, and we're going to have to watch at least 2 hours of it. God, I have got probably 10, maybe more. So we got a couple hours to go through tomorrow, and then we'll have a lot coming out all week next week, and we got premieres happening all weekend long. 8 p.m. Saturday night, 8 p.m. Sunday night. That's Central Time. So come on by and enjoy the chat. If you got nothing else going on and you want to watch some weird court cases, because ladies and gentlemen, I've got some doozies on deck. So, all that being said, thank you very much. I'm your Lone Wolf Usul. I'm your humble curator for these here videos. I am your host for these here little get-togethers every single night of the week. It's Friday. Thank God it's Friday. We got one more day live. One more Saturday. Saturday morning, 11 a.m. Noon Eastern. Come on by, ladies and gentlemen. I'm your Lone Wolf Usul. And for now, I am out. I have it on good authority that Mama Wolfie probably won't like being reminded that she's got a birthday, but we're going to say happy birthday 100,000 times between now and the end of the next show. So, oh yeah, by the way, we're redirecting over to Wolfbot, and I got nothing else. So it's either Wolfbot or Ferris Bueller's Day Off. One of the two. Make a choice. I'm turning this off. We're done now.